We have 3 hearings today. The first one, I will open the hearing on Senate Bill 410. You have a folder in front of you, committee. Eileen, would you like to explain the bill?
Thank you, Madam Chair, members of the committee. Senate Bill 410 amends KSA 9-551 and updates the Kansas Financial Institutions Information Security Act by making 2 changes to the covered entities to which the act applies. First, the bill updates the internal citation from KSA 9-508 to 9-555 and adds language specifying the financial institutions to which the act applies. When read together, the resultant language is that the act shall apply to financial institutions that engage in money transmission as defined in KSA 9-555 and that are also not subject to licensure pursuant to KSA 9-556. So when I said that it added clarifying language, I started off saying clear language or easy language, and then I realized that it really wasn't all that clear the first time I drafted the bill. So if you flip the page, KSA 9-555B at the top of the reverse page lists what money transmission is, and then underneath that I have 9-556, and all the A1 through A16 are the different entities that do not require licensure. So the subset is those entities engaging in money transmission, as you see at the top of the page, and then also are one of the 1 through 16 choices on the second statute. Those are the covered entities to which this act applies. The nut of the bill is actually that the bill adds the earned wage access service registrants to the list of entities to which the act applies. And if approved, the bill would take effect after its publication in the statute book. And with that, Madam Chair, I can stand for questions.
Questions, committee? Okay, thank you. We will hear from our conferees, and maybe we'll have some questions then, just to make sure we understand this bill. The first proponent we have today, and the only proponent, is from the Office of State Bank Commissioner. Louis, would you want to come up, please? Introduce yourself.
Good morning, Madam Chair, members of the committee. My name is Luis Solorio. I am the Assistant General Counsel for the Office of the State Bank Commissioner. In the audience is General Counsel Brock Rayler and IT Examination Manager Kylie Fine for any questions if I cannot answer the questions you might have. The OSBC conducts information technology IT examinations on covered entities pursuant to Kansas Financial Institution Security Act. The Act provides our information technology examiners with the ability to enforce the existing Federal Trade Commission standards of safeguarding customer information on covered entities under state law. Our agency has designated information security examiners that ensure financial institutions doing business in Kansas with Kansas consumers have appropriate information security protocols to protect Kansas highly confidential information. The examiners that conduct these examinations do not perform IT services for the OSBC and solely focus on examinations of covered entities. The principal requested amendment to the Act will allow IT examinations to perform IT examinations on earned wage access registrants. The OSBC requests to include EWA registrants as a covered entity because EWA service providers are already subject to the FTC standards. And they also should be examined at the state level. This bill also strikes KSA 9508 and replaces it with KSA 9-55. KSA 9508 was part of the Kansas Money Transmission, the Kansas Money Transmitter Act, which was repealed last year and replaced with the Kansas Money Transmission Act. Due to the way the new Kansas Money Transmission Act reads, we added language in this bill to include some of the exempted entities listed in KSA 9556 to ensure that the Kansas Financial Institution for Information Security Act carries over to those entities as well. The OSBC would be able to use existing IT examiners to carry out the requirements of the requested amendment to the act and will have a neutral fiscal impact. No additional regulatory burden would be placed on financial institutions to include EWA registrants, as the entities should already be following the federal law. We appreciate the committee's time today and request the committee recommend SB 410. This concludes my oral testimony, and I stand for questions at the appropriate time.
Okay, committee, this is our only proponent in person, and he brought some other experts from OSBC with him. What questions might you have? Anyone? Do you remember the earned wage access bill we passed? Okay, and so from what you've told me, I believe this is just in response to that, to allow the examiners to go in and do what they normally do with that information.
Madam Chair, that is correct. It just includes earned wage access registrants into the act, and then also the exempted entities that are in the KMTA.
Okay, very good. Again, committee, any questions? Okay, thank you, Luis, for being here with us today.
Thank you.
We don't have any written testimony from anyone. We don't have opponents. We don't have neutral. It's a pretty, even though it sounds a little bit technical, it's a pretty clean bill here, or yeah, I guess I would say clean bill. Brock, did you want to say anything? I just want to give you the opportunity since you're representing the OSBC too. Okay, very good. All right, in that case, committee, I will close the hearing on Senate Bill 410. Thank you very much. And we will turn our attention then to Senate Bill 412. You have the folder on your desk. This is conservatorship. As a topic, Eileen, would you want to brief us on this bill?
And thank you again, Madam Chair. Senate Bill 412 amends the probate code relating to guardians and conservators. The bill amends KSA 59-30, 176, and it imposes a new duty upon conservators to notify non-parties to the conservatorship, including financial institutions, of any court order commanding performance or safekeeping of the conservatee's estate assets. If approved, the bill would take effect upon its publication in the statute book, and I can stand for questions.
Committee, do you have any questions of the reviser? Okay, very good. Thank you, Eileen. We have one proponent in person. Brock, would you want to come forward, please? Introduce yourself.
Thank you, Madam Chair and members of the committee. I'm Brock Rayler, General Counsel for Office of the State Bank Commissioner.
Welcome.
So Senate Bill 412, as mentioned, does impose a duty on the conservator to notify financial institutions of any bill that commands performance of the conservatee's assets. In 99.99% of the time, this bill will not be required. This has generally not caused an issue. However, our office did receive a complaint over the last year that this bill attempts to address. And when it comes to our complaints, we are actually held to confidentiality statute that says that we cannot release the details of the complaint. I'm choosing to release the information about the complaint, but not stating the parties in order to protect the confidentiality and also to give you a little bit more understanding as to what happened. This was part of a public case, so that's probably taking a more conservative approach than necessary, but I'm choosing to do so to honor the confidentiality principles under the banking code. In this complaint, there was a joint account held at one of our banks where 2 of the 3 owners were under a judicially supervised conservatorship. The judge and our office independently determined that the bank did not have knowledge of the judge's freeze order on the account. The state bank had no reason to prevent a withdrawal from the third party, as that person was an authorized signer on the account. Subsequently, the 2 owners that were under a conservatorship passed away. That particular account was a joint account with rights of survivorship. And when that happens, it does not become an asset of the estate. It actually will go to the living members of the joint account. So since the bank had already authorized a withdrawal and there was supposed to be a freeze order, in this court case, the judge determined that although the withdrawal may have been a little too early, ultimately that third owner would have received the funds in this account, and basically determined that it was excusable error. It's just a matter of a couple weeks too early when that particular owner would have received the funds. Neither conservatorship needed any access to the funds in that meantime. So ultimately, the judge determined excusable error existed, but this particular complainant did bring up a good point. That judicial order should have been provided to the bank. And we determined that the bank didn't do anything wrong. They had no knowledge of this particular freeze order, so we've closed our complaint. This bill will fix that issue where the state bank did not receive a copy of the order. With that, Chairwoman Dietrich and members of the committee, I'll be more than happy to answer any questions.
Okay. Committee questions, Senator Gossage?
Thank you, Madam Chair. Thank you for this. This is very interesting. I guess what I'm thinking is non-party seems very broad. Aren't we all a non-party to that conservatorship? How do we determine, or is that a technical term for non-parties?
That's a very good question, Senator Gossage. I do believe that someone should be notifying anyone if there's any sort of order on assets that are in the conservatorship. They should be notified. It is rather broad. It would also include things like brokerage accounts and other financial institutions. But I think someone should have the duty to notify. In this case, the person that would be best handled to do that would be the conservator. Thank
you, Madam Chair. Thank you.
So if I might add on to the question that Senator Gossage asked, isn't someone assigned as the conservator? So anybody who's not technically named as a conservator is a non-party? Would that be correct?
Good point, and thank you, Chairwoman Dietrich. Yes, a non-party would be someone that is not a named party in the judicially ordered conservatorship.
So just to take that one step further, because I was a party to many of these emails that were generated by the family members who were not parties to the conservatorship, that really became, the issue became, as Brock said, who has a responsibility to notify the bank that there is a judgment? And so the conservator is the person responsible, but we didn't have that language in statute. So other family members became upset because actions were taken, but they weren't named as conservators and they were non-parties. So at least in this manner, the bank must be informed. So Senator Warren.
Thank you, Madam Chair, and appreciate the discussion. This is an area of law I practice in, so a couple of questions. My big concern is non-parties. Well, usually the party to the conservatorship is the conservator and the conservatee, period. So like we've heard, anyone else in the universe would be a non-party. So I find it way too broad, way too vague, and no conservator would be on proper notice with this to who they're supposed to notify. Was the first point I wanted to raise. And the second is, who was bringing, and I don't mean a name, but how were they involved with this conservatorship that they had an opportunity to complain that the bank was mishandling the assets, because the conservator is appointed through a judicial process. The family is usually notified, the family of the conservatee, hey, this person has filed a petition to be the conservator. Anyone who objects because you don't trust that person or they're not capable, please come forward. That notice has to be given before the conservator is named and put in place over the assets of the conservatee. So who was bringing this complaint? It was a family member? Is that what you had said?
Yes, it was a family member.
Okay, and then in this instance anyway, it was a joint account with rights of survivorship. And oftentimes accounts are set up that to pass the asset without the necessity of going to probate, which is why a lot of people do trusts and things to avoid the cost in the process of probate, that you have a joint account with right of survivorship. So it passed correctly also. The conservatees passed away, and then they were joint account owners. So I understand that it was frustrating that the bank wasn't notified. So if we're going to do something along this line, I would find it would need to be much more narrow. And sometimes it's hard to find a conservator, right? Because, you know, family members are busy with their own families. And so I would just want some guidance from your office about what you intend to mean by non-parties.
Good question.
Chairman Dietrich, the intent here is simply, I think the conservator is in the best position, but to be perfectly honest, if there is a motion made to limit it to financial institutions, we'd be in support of that.
To which institutions did you say?
Financial institutions.
Does that include, because there's many assets that can be in a conservatorship, brokerage accounts, annuity accounts? I mean, we've had to work through the trust owned by the conservatee and tracking down all those assets. But some clarity would be helpful if it has some intent of moving forward, I would suggest.
I would like to move this forward simply because I think the family who first contacted all of us about this issue felt that there was not enough language to for the conservator to be able to notify the bank. So that would really be the goal. The conservator has a responsibility to report it to the bank. Does that, so how would you, I guess I would ask, how
Well,
would you-
where the account for the conservatorship is housed, I guess, is that the intent?
Yes.
Yeah, where there's usually a conservator account where the conservator can, you know, pay for the daily needs of the conservatee but you know, you're managing the assets also. So, you know, it's not necessarily just cash in a bank account. So, you know, do you need to, you know, notify, you know, the life insurance company and everybody, so.
One question I do have, and this is a little outside of our area because we typically don't deal with probate. Our idea is the accounts have already been identified by the judge as an asset. So I'm wondering how much tracking down the conservator needs to do, because I was under the understanding that the judge and the conservator have already identified these accounts and they're placing a hold on it at that point. But if there's additional language, I'm more than happy to consider that.
Sure, and Madam Chair, yeah, I'm happy to talk with you offline and work on something to kind of bring it more concise so our conservators can know what they're supposed to be doing.
Great, that would be perfect. Thank you very much, Senator. We have another question from Senator Fagg.
Thank you, Madam Chairman, and I really like the line of questions we have coming from Senator Warren. A couple of things I find interesting, because I think I talked to these people last summer, and the more I heard this story, the crazier it got. So the thing that the conservator on this was also the third party. So when you talk about this right of survivorship, that kind of plays into this a little bit too, in my opinion. The other thing, I think there was a lockbox involved, so that goes into what Senator Warren's saying, how that process goes. So how you identify all that and who's responsible. So I really like that we're bringing this forward, and if there was some kind of good amendment to open that up that included those kind of items would be a great thing to do.
It would. Thank you. Any other questions, committee? Okay.
All right.
Thank you, Brock. We have a proponent written testimony from Kelly Van Zwal from the Bankers Association. We don't have any opponents. So if there are no further questions or discussions, I will close the hearing on Senate Bill 412. We are just moving right along. I am going to open the hearing on Senate Bill 472. You've got your folders in front of you. Let me just do, and Eileen, would you give us a second as we manage our folders and then brief us on this bill? Actually, it's me that needs a minute. Thank you. Thank you. All right. Ready. Thank you, Eileen.
Thank you, Madam Chair, members of the committee. Senate Bill 472 authorizes the Securities Administrator to set the amount of certain fees and requires the Commissioner of Insurance to publish the amount of those fees in the Kansas Register. The bill also eliminates the 10% credit to the State General Fund as reimbursement for certain state-provided services. Senate Bill 472 amends the Uniform Securities Act to authorize the Securities Administrator to set the amount of certain fees up to a maximum dollar amount that was already, for the most part, statutorily prescribed. The bill also authorizes the Commissioner to publish the amount of that fee set by the Administrator in the Kansas Register not later than December 1st for the next calendar year. The Commissioner is required to publish that fee pursuant to legislation the legislature passed in the 2025 session granting such authority. The bill also amends 2 insurance statutes. The first one authorizes the Commissioner to set the amount of the fee charged for insurance agent licensure not to exceed $150, and again requires the Commissioner to publish the amount of that fee in the register by December 1st for the upcoming year, and also authorizes the Commissioner to set and publish the fee for the public adjuster license. Lastly, the bill eliminates the 10% credit to the State General Fund from each deposit to the Securities Act fee fund made from fees, charges, and deposits from the issuance, sale, or disposal of securities or the regulation of dealers. And if approved, this bill would take effect upon its publication in the statute book. And I can stand for questions.
Committee, do you have any questions for the reviser? Okay, if not, then thank you, Eileen. Our first proponent and only proponent is Eric Durek. Eric, come forward.
Madam Chair, members of the committee, appreciate the opportunity to provide proponent testimony on Senate Bill 472. I'm Eric Turek with the Department of Insurance. As the reviser stated, this may sound relatively familiar to all the members on this committee. In 2023, the Department of Insurance introduced legislation that would let the Commissioner of Insurance lower insurance agent licensure fees. This is just the initial application fee for those agents. In statute, it's $30 for resident agents and it's $80 for non-resident agents. Since we have published a fee in the register that's been below that amount, and so for the entire calendar year for 2026, it's $15 for resident agents and it's $40 for non-resident agents. So that, and we've been doing that since the enactment of that bill, which was House Bill 2090. Last year, you all passed a bill very, very similar that let the Commissioner do the same thing for about 100 different insurance fees. And so for this calendar year, we expect to save the industry a little bit more than $1 million. I don't know if I would use the word cleanup, but there were 2 fees that were excluded from that total list. We're just completing that list. It's for those that the reviser stated. On that same front, typically when we come here, we talk a lot about insurance. We don't talk a lot about securities. The rest of this bill pertains to securities. In 2017, the Office of the Securities Commissioner merged with the Department of Insurance. We fully regulate insurance and securities under one roof now. A lot of our securities fees, they already contain, in statute, they contain the language not to exceed. So if you look at that first section of the bill, it says that the administrator may set a fee not to exceed $2,500, okay? We already have that authority. We publish that in regulation. What we would like to do is have the flexibility to publish that in the register rather than go through the regs process to just change the fee. And that applies to every single one of our fees. So for an example, the investment advisor representative there, I'm looking at the bill, I can't find the exact section. For an investment advisor representative, the statute says that the fee shall not exceed $100. In reg, it's $60. If we want to lower that, we just want the flexibility to do that. Truly, with all of these bills, we just want to achieve an equilibrium where our revenues meet our expenses. If you look at our testimony, past fiscal year 2021, there have been some years where we have charged $0 for securities fees because truly we have this is our attempt to achieve that equilibrium with the way that statute, and it's not in this bill, the statute currently reads that we may waive in whole or in part these fees. And so, though we can't customize the fees like we can on the insurance side. So we really just, rather than ebbing and flowing with charging 0, charging 50%, what's in reg, it's just very confusing for the industry. We really would just like to publish these in the register, continue what we're doing and making sure that our expenses, our revenues are meeting our expenses. And lastly, some of you who have been on appropriations and Ways and Means, or some of you who are attuned or familiar with smaller agencies and how their budgets work, there are a handful of smaller agencies that do not have their own payroll services. They don't have their own legal services. They are required by statute to transfer $100,000, 10% of their revenue, or up to $100,000 to the SGF, so that way the Department of Administration can provide those benefits to those small agencies. Think of Board of Technical Professions, the Dental Board. It's on the last page there, is that whole section that's being changed, or where long story short, Madam Chair, the Office of the Securities Commissioner, while it's still technically a standalone agency in statute, it is housed within the Department of Insurance. We have our own HR, we have our own payroll, we've had that for some time. We are asking that the legislature cease that transfer. There's nothing being gained from this transfer in terms of the department. We have our own HR, we have our own legal services. This is honestly cleanup that really should have happened a couple years ago. So I'd be happy to stand for questions.
Thank you. I do have one real quick. I think during some discussions about this bill, I believe you or someone said from the department that 100,000 just flows through SGF to Department of Administration to do all those payroll services and HR services that you currently do in-house. Am I correct?
So, Madam Chair, so the $100,000 goes to the SGF. Whether that gets to the Department of Administration, that's I can't speak to that necessarily, although there are no services rendered from the Department of Administration, or any agency for that matter, relative to all the services. If you look at the back page, line 19, budgeting, legal, payroll, personnel, there's no other agency that does this except the Department of Insurance. So, and this is for the insurance and the security side. So there's no other agency that assists us in this with these relevant services.
Thank you. Committee questions? Senator Gossage?
Thank you, Madam Chair. Eric, regarding that, on this last paragraph from the testimony, it says KSA 753170A requires most smaller state agencies to transfer 10% of their revenue. So how could the department be the only one that does that?
Let me clarify. So there are some agencies that absolutely utilize the services of the Department of Administration for those services. All those agencies are listed there. I gave you a couple, Board of Healing Arts, the Dental Board, the Board of Technical Professions. The Office of the Securities Commissioner is still codified there. It's truly a remnant that should have been stricken when the department and the Office of the Securities Commissioner merged. Did I answer your question?
It does. So what you're saying is that they don't really use these services, so the transferring of that there. Also, in reading through the bill, it just makes sense that it says, and I think that just changing everywhere in the bill is not more than just says shall not exceed, doesn't change the amount, just changes the way that it's stated. That makes perfect sense to me, and I have no problem with the bill.
Questions? Senator Fagg?
Thank you, Madam Chair. Eric, thank you for your presentation. When I see this 10% credit, do you have any idea how long that's been in law? That kind of thing? And to kind of go along with that, that 10% was put there for a reason, I would think. Is there any cost outside the insurance office that the state of Kansas, where they're trying to cover that 10%? Or is that just revenue? Just wondered if you'd comment on that.
Sure. Without looking at the statute itself, I can't tell you how old the statute is. What I can tell you is that not every agency is a part of the statute. Not every agency transfers 10% or up to $100,000, you know. I could name, 50% of agencies in Kansas, larger agencies especially, don't do this. They have their own in-house legal, their own in-house payroll, personnel, purchasing services, things like that. Effectively, we function like any other larger agency, especially for the other statewide elected officials. It's just that this specifically, that Chapter 17 reference there to the Office of the Securities Commissioner, we really do think that that should have been stricken a long time ago when it merged. Again, because there's no, maybe at one time, absolutely, that money was used for legal services, for payroll, et cetera. It's no longer, another agency isn't doing the work for us anymore. So, and it looks like the reviser may have a
Oh, yes,
clarifying.
go ahead. Yeah. If that's all right with you. Eileen, go ahead.
Thank you, Madam Chair. The statute was enacted in 1973, and looking at the history, it looks like it was amended almost every single year up until 2018.
Thank you. Senator Gossage.
Thank you, Madam Chair. Just to follow up, Eric, so when they merged, I think that was in 2014 or 2015, if I remember correctly, then instead of being a small department, the securities separate department, it fell under the larger department of the insurance commissioner's office. So therefore, all of those things that were done prior are now done within the department of the insurance department. Does that make sense?
Exactly.
Okay, thank you.
Thank you. Any other questions, committee? Senator Fagg?
Thank you, Madam Chair. One quick one here. The $2,500 fee, what do we actually charge right now?
You're talking about in section 1 right there?
Yeah.
You know, that is I would actually urge you to look at any other section other than that. That's a very niche section, and I think for that fee specifically, we've charged it only 6 times in the past 10 years. I think for something more applicable, I would look to page, something more, again, easy for the committee to digest. If you look at page 5, there's a whole bunch of different, the fees are spelled out there for broker-dealer agents, investment advisors, investment advisor representatives. Specifically, if I'm looking at that section 4, the investment advisor representatives, the people who are providing financial advice to Kansans, the fee right now in statute is $100. In regulation, it's $60. Although for this calendar year, we are charging $0 for every single one of these. So I hope that answers your question.
So I'm just wondering, from the numbers you threw around there, why 2,500?
Why 2,500 specifically for the exemption from securities registration? That's a great question, Madam Chair. Again, this fee is, I think it's been only used like 6 times in the past 10 years.
Do you want to phone a friend?
Our Assistant Commissioner of Insurance is here, Clay Johnson. He's actually the former general counsel, former staff at the Office of the Securities Commissioner once upon a time, if I wouldn't mind calling on a friend.
Absolutely. Welcome to committee.
Thank you very much, Madam Chair.
Would you introduce yourself? And
Clay Johnson. I'm the Assistant Insurance Commissioner now, but I've worked for the Securities Division since 2016, mostly in a legal capacity. With respect to the exemptions, up to $2,500, there are a lot of securities registrations exemptions under the Act. Most of those are no fee. There's only one that charges a fee, and that is $250. I think that the wide range of $2,500 for exemptions is part of kind of the Uniform Act structure, in which many states use this act as a little bit of a revenue generator. And we've just never done that. So the securities registration exemptions are all 0, except for one that is a credit investor exemption that's $250 said in reg. That accredited investor exemption has been used since 2016 about 3 times in my experience. So they're little used. Most of those exemptions are self-executing. We don't even know how often they're used because the people using them do not need to file any forms or pay any costs with us.
So this is talking about set a fee not to exceed. You was talking about exemptions. You mean this, and I like to have a little buffer in there, don't get me wrong. I just wondered why the 2,500 was the magic number.
I don't know why that was established in statute originally, but the most we've ever exacted was $250 under that statutory exception.
Thank you.
Okay. Eileen, did you have something to add?
Only that the fee was established at the enactment of the statute itself back in 2004.
2004. Good. Committee, any other questions for our conferees or the revisor? Just any more questions? Okay. If not seeing any, we will close. Oh, and there are no opponents. There's no written testimony. We just have the oral testimony from Eric. There are always, and I may not always remind you this, but there are fiscal notes in your folders as well. Committee, I will close the hearing on Senate Bill 472. And since we've got a couple minutes, there's one bill that we heard on February 3rd, I believe it was, that we could work today, shouldn't take too long. And then, just as an FYI, tomorrow we have a hearing, Senate Bill 115. I don't know if we'll have time to work any bills. After that, we might. Monday is our last day to meet, and we will work whatever's left, 3 or 4 bills, not a lot, 3 or 4. And the bill that I would like you to take a look at is Senate Bill 472. Wait a minute. What are you telling me? I've got 2 people talking to me, 1 question. Oh, I'm sorry. Yes, besides Senate Bill 115, tomorrow we have Senate Bill 422. Thank you. Yeah. Yeah. And we're going to work, if we have the chance, Senate Bill 232. That's foreign investments. That the Treasurer's Office brought us. Do you have that folder? If you want to pull that out. Senate Bill 232. And I think because it was, we've had a few sleeps since then, if Eileen could briefly remind us. Senate Bill 232. Oh, we don't have the amendments yet? Okay, very good. We are not going to work 232. Treasurer's Office has an amendment. We haven't got it quite yet, so I jumped the gun on that. I apologize. Well, after all that, we're going to adjourn this committee and you get out of here early. Thank you so much. Be prepared for tomorrow. Thank you.